Maybe very wise.
All right, we're back. This is Senate Health and Welfare, back again on H 121, consumer privacy. And I think the debate right now, to be quite honest, is the PRA and the testimony that we heard from Senator Ron Hinsdale, who has gone ahead and talked with other committees and identified that there will be other committees standing on the floor opposing any PRA that we put forward. So we're not, at this point, we're talking about, I think, Sisyphus and the reality, the political reality that we face should we continue with a private right of action, which I think is really important personally. It is critically important, but there's some fears out there and some concerns that we don't have, that healthcare and other businesses don't have the processes in place or the money in place to defend what might be a deluge of what could be frivolous or not frivolous lawsuits. At the same time, there are exemptions in this bill that really I continue to be concerned about. And I mentioned those earlier. So I think it's our intent in here, at least, that our intent in here has been, we want to see some accountability and some responsibility. And that can happen through a PRA with a cure period that we've proposed in the bill, and the cure period that the AG's office has talked about does offer relief for businesses. At the same time, a private right of action, whether it's put out in 2025 or not, is concerning to businesses. So my mind has gone to the political reality of standing on the floor and defending something that in effect is not going to be voted on and would be stricken on the floor. And I think for our committee purposes, where we've been so concerned about healthcare, we've done some good work, and I really appreciate the work that you've done on this, John. But I think my suggestion would be to put some intent language in that we intend to see a private right of action proposal, and that this would allow for some accountability and some responsibility for all of us. It's just we all need that because we're in an age of technology that we never anticipated 10 years ago. We're in an age of technology that we didn't anticipate 3 years ago. So that's my speech. Right. I'm open to suggestions from the committee.
So in summary, you're not in favor of a private right of action.
I am in favor of a private right
In the bill.
in
at
this,
moment.
but not in this bill at this moment. But the intention of continuing something I think is important. I know the AG is now on the edge of his seat. And I would, let me have my committee members finish their comments, but then I would allow.
No, it's good.
I'll just say, I really appreciate all the work you did, and I'm disappointed because I think it was a step in the right direction, but I understand the political realities of the building, so. We got it,
Not the building, it's the first floor.
the world, the first floor, okay.
All right. Senator Wayne, so. Okay, smiling.
You're doing all that. It's a
Oh.
Friday smile.
Oh, this is like Friday smile. Chris Curtis.
Would you like me to chair, Madam Chair, or should I just opine
No,
from
stay
that?
right there
Okay, very
because
good.
we're gonna be moving at a clip.
Yes, indeed. So for the record, Christopher Curtis, I'm Assistant Attorney General for the state of Vermont and work in the Consumer Protection Unit of our office. Just briefly, one constructive suggestion to maybe get you where where your committee appears to be leaning, but where you have concerns about the larger body, might be to focus on the sensitive data provision that relates expressly to biometric information. So having a private right of action for biometric information specifically, which guards against deep fakes, non-consensual use and aggregation and scraping of your personal photographs that are all over the internet that people can use indiscriminately without your knowledge or consent. That is what Illinois did. That is already well established, and unlike Illinois, Vermont has the cure period, so it would guard against some pretty egregious potential violations that are out there with respect to companies that might be using artificial intelligence and other things to manipulate your image or your voice, or things that are just kind of out there that are really hard once they're out to reel back in. It's not like you can just call up and get a credit freeze when somebody steals your picture or video and puts words in your mouth. Right? Those are really serious egregious violations. So there's precedent for that. It's been done. That doesn't, it's not as expansive as what you currently have before you, covering all of the sensitive data provisions, right? So that would eliminate the concerns that some have about, is this too far reaching? And it would really limit it and focus in on saying those statutory damages where consumers really should have a right to protect themselves. We're focused on the biometrics.
So I hear you,
Yeah.
and I would love to do that.
Yeah.
It is not directly related to our committee, and I'm trying to avoid the conflict with the Economic Development Committee.
Mhm.
We can put, and becomes a jurisdictional issue, and I'm very sensitive to that myself, so I want to make sure I respect it for others. And, but there's no reason why we can't put some intent language around what should be addressed first in terms of private right of action. I look to,
So I find if that's what you want to do. Another approach is just to build out that report section instead of having intent language and saying, develop a private and implementable private right of action as part of that report. They come back with a report that says, here's your private right of action. So you wouldn't just have intent language. You would then be tasking someone with actually developing the,
yes, I like that,
um,
like that. I like that. I don't know whether my committee likes that.
You reference, deputy AG,
Assistant.
assistant AG's
AG.
comment, so if I understand the bill correctly at this point, we are including a cure period to allow, okay, and we are including the biometrics of photos and videos protection. Okay, to that point, I just want to make sure Spill's been kind of moving quickly, and I want to make sure that his comments weren't in relation to the fact that they may have been stripped at some point over the past.
We haven't taken that.
Okay.
And Senator, just to be clear, Attorney General supports your efforts to focus this on sensitive data. However, it was just a clarification that if you intended to narrow before the bill might come to the floor, that might be one way of doing it. So we do support your efforts in this area, the proposed amendment.
Well, so Senator Harding is.
I'm sorry,
Okay.
I didn't see
Okay.
Senator Hewlett's text.
You'll- okay. So, I have suggested that because of the culture and the political environment we will face on the floor of the Senate from 4 other committees. 2, 3 other committees. That we put our PRA, we put intent language in, or language in the report that asks for legislation to come back on a private right of, on a PRA, private right of action. And included within that is, in particular, sensitive biometric data. So as suggested, I know the AG, that's really out of our area, but put that in.
But I'm
I know.
confused as to what you're.
You missed it. I want to hear from Senator Bullock first, and we'll go back, because we don't have
No,
time.
I'm disappointed that we're basically just putting it into a study, so to speak, a report. I don't think that's strong enough. Having said that, again, I will follow the lead of my chair and, the political winds,
Yeah, I mean, the political reality is it's not gonna go anywhere. It will result in a floor fight that is probably not going to be winnable based on the votes that we would find. And and so my thinking is, as I indicated earlier, we heard from Senator Rom Hinsdale that she's already talked with other committees about this. And that, and some of what is in our proposal is outside of our jurisdiction, so I can respect that comment. So having
What is outside of our jurisdiction?
the PRA on, more businesses than healthcare.
I thought we narrowed, it's just on healthcare.
Sensitive data does encompass things beyond just consumer health data, financial data, which could have health pieces, but there's financial data that is not. So there are elements of sensitive data that are not health specific. However, a lot of the health specific concerns are in the sensitive data bucket, and that's why you guys have elected for this section.
Yeah, it's confusing. So, yes, I'm feeling the way you look right now.
I'm sorry, I know you had something to say, so
No, I'm done.
I'll wait my
I
turn.
just said my piece.
I think we did our work and we came to a conclusion based on the testimony we received and that we should stay with what we have. And if there's gonna be a floor fight, bring it.
That's the usual response. Senator Luciano.
No, I'd just like to add that, for those of us who live constantly in a world of compromise, I think it's an okay compromise. You may get what you want downrange, but I think it at least moves the bill forward, and the bill's important. So I'm okay with the concept you've outlined.
With the intent and the legislative.
I'm not hot on intent, but,
No, the legislative language coming back,
Yeah.
and, yeah, and look, the bill doesn't go into effect until what, 2025?
Yep.
So whatever we do here doesn't go into effect until 2025.
Except for the council, sorry, the council would be
Yes,
immediate. so they can
Council
start
is
doing
immediate,
work.
and that's the place where we would get the legislative recommendation. So I'm very sympathetic to Senator Hardy's comment, and it would be absolutely important to educate our peers about why it's important to go forward. We can do that regardless, on the floor. And it would be a far better educational experience, given, what the debate could be. So educating them about, this is what we need, this is why we need it, and our intent is to have legislation back. And we will be working very hard to ensure that there's a PRA in place, and that the cure is in place, and that the procedures for businesses is in place. I mean, it doesn't appear to me that you need to reinvent a wheel along the way, but stop it there.
Yeah, I just, one final thought for your consideration, and I can't say this is a formal position of the Attorney General as it stands right now, but given your committee's inclination and interest vis-a-vis sensitive health data and providing that consumers have a private right of action, another way to potentially get at this that preserves and creates the placeholder that you're seeking through the report, but actually does something now, is to say a violation of the subsection relating to sensitive data, which includes health data, is a violation of the Consumer Protection Act. With that, there's no statutory damages. You would just have to prove damages. If you could prove damages, then you could bring a claim. But it doesn't open the door to say for anybody that had a violation, if it's ethereal or they're not even sure that they somehow get, a statutory damages amount. And I think that's been some of what has maybe fueled some of the concerns around the Illinois law, where it's kind of a blinking light that says if there's a violation, you get $1,000 or you get $5,000. That would be more consistent with what Washington did in its My Data, My Health law that says if there's a violation of this, it may be a violation of the Consumer Protection Act.
Yes.
You have to prove your claim now, and you have to prove the actual damages so a court can rule on that. And that's going to be particular to each person because there's different types of violations and different sizes of harms. And so if it's very de minimis or if you can't prove it, you're not going to get anything. And in addition, of course, you still preserve that cure period. So it's a way to have the private right of action, but in a way that I think puts more of the onus on the consumer to actually have a verified and actual claim and not perhaps have these fears of, everyone's gonna run to the courthouses automatically if they think they get, free money, so to speak. And that's an oversimplification, but I want to put that out there because you've done that in many, many other consumer protection laws around Vermont government. You say when there's a consumer protection law, if there's a violation of this act, it's a violation of the Consumer Protection Act. It happens all the time, it's all throughout the green books. And then the consumer has to really prove their claim. That's a little different than a statutory damages framework.
Let's work with that.
So that might be a place to protect your sensitive data piece, have the PRA there. That's just for your consideration. I can confirm with our office that we're, comfortable with having that there. You could consider statutory damages later in the
That better
report.
confirm soon.
Yeah,
I don't want to cut this down. I will tell you, you're going to get the same response
Okay,
from the other committees to that proposal. I don't want to,
No, it's good.
that's great if you guys want to do that. I have, I don't want to like
no,
tamper down I just expect that that's what you
Great suggestion.
get, because they're still gonna say
Okay,
it's a private right of action.
Yeah.
But I do take the point that,
well, we could put that into the consideration, but we're gonna get legislation coming back. That's what we want. We want legislation coming, or at least I do.
I'm a no on this amendment if we can take this out. And I'm also gonna speak on the floor. I'm just giving you notice,
Yeah.
Chair.
Do that. I'd be glad to have you do that.
The other body did exceptional work on this and
They did.
I
They did a
don't
huge amount.
feel like the same has been done on this side, except for this committee room.
So, okay. The question then is, Michael, we're gonna do it today, so please come in and have a seat.
Oh, you thought you were sending him away.
I wasn't sure what to expect.
Thank you for being here. So, Martine, so.
Yes, yeah, I'm just
Um,
moving around.
okay. So. I'm listening to my committee right now. The suggestion is made to put some intent language in on bringing legislative language back on a PRA. So I'm listening to my committee.
can I
I've
say,
heard Senator Vardy.
Can you repeat the question?
may I say something on?
Yeah.
Just to be clear, the report will be coming from that council, so it will be recommendations for, it can be in the form of legislation, but that would not be staffed by legislative council. So they will have recommendations for policy, but the idea that it's gonna come in some perfectly drafted legislative form, I don't think that's. There could be good ideas. I'm just trying to make clear that if you're expecting, you're gonna have language day one that arrives from them, I don't know that that's the case. But what they will recommend is, and I can read out the language that I've drafted here on this piece. Recommendations for developing and implementing a private right of action that provides a clear process for consumers and controllers, processors, and consumer health data controllers to follow. So they would be providing kind of policy recommendation, which could include language, but it would not be me doing that.
No, we get it. We know. It's the group.
Just to be clear.
I'm actually not saying that from a self-protective standpoint. I'm saying it so that you are aware that you're not receiving that product. That's
We understand that.
truly not
As much as we
self-interested.
would like to have you be doing it, and if they end up that you are doing it for,
Yep, you never know.
Sounds like a policy.
this is a policy decision. Do we want to leave the PRA in as it is currently? Or do we want to move it to hello to the report?
And
Well, I'm gonna break the tie.
I'd like it in, I would be up for considering what the AG's office just recommended.
Yeah, yeah. The consumer protection, which will be the same as a PRA.
But it will be a narrower and less, it wouldn't have the statutory damage.
less scorched earth kind of. I would,
Okay, we didn't talk about that, so let's talk about that one first. Consumer protection, I'm looking at, do you wanna add, put the consumer protection narrower piece into the bill instead of taking it out? It'll still be in, the report will still have a ERA. Is that of interest? Yes?
Yes, I would be
And, okay,
interested in
no,
where.
just yes or no? Okay.
Or,
Sorry, I missed the question.
So,
My apologies.
no, having the consumer protection piece that narrows the PRA.
Obviously,
Well, leave that.
The way that it narrows is, I think, limited to there may be more to this, but the damages piece basically is still the same harm it's triggering. That's what you guys were trying to get at. It's basically where's the PRA located, and the advantage that's being offered is that if it's deemed to be the availability of actual damages that will create frivolous litigation or all kinds of settlement that could handicap people, that might be removed by moving the private right of action to the underlying statutes. That's fine if you guys want to do it, but I would make the same point. People are still going to say you're including a private right of action, and they're going to object on that basis. So I defer to the AG's position as to whether or not that does reduce frivolous lawsuits. That argument makes sense to me, but I think you're going to face, if the reason that you were abandoning this course of action was that you're going to face a bunch of committees objecting to including a private right of action, you still would be. That's all that I am trying to say. And again, I'm not trying to discourage this. I just want you to know that is your basis for stepping back from what's already in the bill. I mean, another way to step back from that is to remove the actual damages piece from what is in the private right of action here. Or sorry, the $1,000 piece, the greater of 1,000 are actual damages, so that then people don't know that, you know, I bring a suit and I automatically am gonna get at least $1,000 if I win.
right, and that latter thing is what?
Exactly,
That's what-
that's the
that's
advantage
what
that's
the-
suggested, basically.
Exactly.
Okay. So now. I'm forgetting where we are. But so the question is it the Consumer Protection Division PRA language? The interest in that, if you're interested in having that, just raise your hand.
The
Yeah,
AG's suggestion.
the AG suggestion
The AG suggestion, okay, yes.
Yes.
to that, okay. All right, good, we'll put that in,
Compromise.
huh?
It's compromise.
It is a compromise and it will do,
Did you get the okay there from your boss?
we haven't had approval from the AG yet, but
Right.
we'll go for that. Let's
So-
let it.
So I was prepared to give you a document that had the requests. I am no longer prepared to give you a document that has these requests, so I can do this, but I will not be able to do it right now is the only thing, because I have to turn to H687 stuff. I know that we haven't done second reading of this yet, so I
No.
think we have some
Right,
time.
we'll probably, it seems to me that this is gonna pop up on third reading, if,
Right.
I don't know when that will be, so.
Yep.
Hello, okay, so let's go for that, and then, let's not come back to this, let's look at this proposal, and then we'll take it to the floor. As long as the AG is agreeable, now, second issue we have, if the AG comes back and says, no way, I can support this. We're not gonna do that, so then what is the fallback position? Fallback position, we have two options, one, we stick with our PRA as it is, or two, we ask for legislation coming back with that report, so. I'm just gonna poll the committee on what your second choice would be. So committee, what is your second choice?
Can I ask a clarifying question?
Yeah.
So if we were to leave it as is and bring it onto the floor and then have a discussion on the floor about it, what is the consequence of, so what is the amendment either gonna go down or up?
Well, they'll strip out,
We would strip that
they'll
out.
probably, or they'll
Divide
say,
the question or something.
divide the question, take that out.
Okay.
That would be it. That'll be a discussion.
Okay,
Okay.
yeah, I'm okay with that.
Leaving the PRA rather than the intent. What are your,
Couldn't there be a third option?
which is,
Take the PRA out?
That's what I'm saying, take the PRA out and put the intent language in, those are the two options we have. PRA,
It's report language.
report, PRA in report with legislative coming back. So, you want PRA?
Are we,
I'm just a poll for a second.
I think we should have the PRA. I
Okay,
think that it is important, and I think the narrower version, or if it is that, is a good idea,
okay,
and we should do that.
okay, so the narrower version is our first choice, we've already decided that one, but now we're looking at
Oh.
second choice, backup plan is
Oh.
PRA or report. Report.
So while I really like to see the supermajority battling out on the floor.
That brings you joy,
I'm
that's.
not, I don't support the peer.
Okay, all right.
But I do support the language that studies the concept for the future.
That's too. I am not looking forward.
So I don't know where we've ended up, like.
It's very clear. We've ended up with the language that it goes to the consumer
Okay.
protection.
Underlying consumer fraud protection, private right of action,
Yes. Yes.
based on the same sets of harms that were contemplated here.
Yes.
It's the second choice.
So hold the second place.
Leave it,
Hold
okay,
the second
leave
place
it.
is. Got it, okay. All right, so whenever, because you have to go do 6, 8, 7.
Yep.
Good luck.
Have fun.
Okay. Abruptly, I'm out this door. All right.
Thank you so much,
Thank you.
everyone.
See you guys. Yes. And feel free to, I'll see you guys again.
It's not fun when it becomes a political, cultural determination of how we proceed, but it may actually help.
Yeah, and I think that
A lot
you
of
will,
people thinking about this.
I think you will find similar reactions to this proposal to what you have found to what you've already proposed. So, just for, yeah.
We get it.
Yes, yep.
Thank you.
Michael,
I'm sure.
it's great to see you.
As Kiki will tell, Michael Chernick, legislative counsel for the record, as Kiki will tell you, we have exchanged multiple email and scheduling appointments in the last 10 days. And I've never been quite sure if I'm actually coming or not, right to the last second. But with that being said, good morning again. My name is Michael Chernick, legislative counsel. And we are here to look at the latest revision of a strike-all amendment to JRS 444, which is a joint resolution declaring the increasing number of drug overdose deaths in Vermont to be a public health emergency. And I don't know, you want to put the version on the board or through your computers, but I sent her, and you should, after I misfired and sent an attachmentless email, I did resend it to her about 10 minutes ago. She has the latest version, I have the latest version on the paper as well.
Can you put it on there? Keep it on the front.